name's David Lincoln. I'm a geologist and environmental consultant. I'm here representing Sierra Club. And when I was here a month ago, I was pretty angry with Exxon and the kind of things that they have done. But now that I have had a chance to study the details and really look into the approach that they used, now I'm really mad. You may recognize this map. This is the one that is on the website. And basically it shows Mayflower, and it shows the distribution of all the recovery equipment and all the things that Exxon mobilized to help clean up various samples of oil that they had. That's about where the oil spill occurred. Exxon decided that they would use enough equipment to clean up about 10,000 barrels of oil. And you can decide for yourself whether they actually mobilized that. But what I want to do next is I want to take you back to that traumatic morning of March 29th, and we'll look at what Exxon did, and we'll look at how common sense might have instructed them to do something a little differently. So one of the things that makes me mad about Exxon's response is they did things that you and I could not possibly do because there are laws against it, and they did things that didn't make a lot of sense. And I'll show you what I mean. March 29th, the oil spill occurred, and they sent out their response team. And the first thing they did was deploy directly onto the site of the spill. As I'll show you in a minute, maybe a little too close. Yeah. Here's a close-up of that site where the oil spill occurred, and you may notice that where they identified the spill, there don't seem to be any houses, which is a little strange because we know there are houses there. We've seen it on video. And what that means is that the image that they gave out to all the institutions and agencies probably is 2009 or 2010. So what does that mean in practice? Well, it means I have better maps on my phone than Exxon, with its vast resources, issued to all the agencies, which became the official source of information. And you may notice that when they deployed their trucks, their vacuum trucks, they put one on top of the pipeline, they put one over at the end of the neighborhood where they saw the spill, and they deployed the others in the channels where the oil was migrating. Now you might ask yourself, wouldn't it have made more sense to put a few more trucks in here to prevent the oil from getting here? But they didn't do that. So let's talk about the oil spill, for example. If you lived there and you decided to change your oil on the street, you would be fined for polluting the neighborhood. And if you said, well, it's not that important because we can push it into the storm drains, you would be fined for polluting the storm drains. Not only that, but the stuff that you would be using is both flammable and explosive. So naturally, the first thought you would have is, good, let's push it into the sewers. The next thing they did is they decided, well, if we can get it out of view, then let's get it through the storm drains and get it down into where? The wetlands. Where we know we can't clean it up because they've had lots of experience with oil spills in wetlands, and particularly with these tar sands in the Kalamazoo River, they know that these things cannot be easily absorbed and cannot be cleaned up. So you would be fined again by not only doing damage to the wetlands, but in the recovery operation, you would be fined if you just sent bulldozers into the wetlands and started clearing away. Not only that, you would also be required to restore the wetlands, not only to their previous condition, but you would have to plant wetlands and make sure that the total area of wetlands was not decreased. How much of that did Exxon do? Well, not much. Yeah. So here's a satellite image, which I can get on my phone. This is still pre-spill, 2012. As far as I know, there aren't any satellite images of the post-spill area. I keep looking. But you can quite easily see the base of the pipeline right through there. And sure enough, these are the three houses. 1, 2, 3. And these are their driveways. Maybe putting driveways over the pipeline is a very good idea. This is a close-up of that image in February 21, 2012. And again, this is the Pegasus pipeline. And where do you suppose they park their trucks? That look familiar? There it is, sitting right there on top of the pipeline. The pipeline is buried between a foot and 2 feet, if you're lucky. And they had that truck going back and forth, over and back, across that pipeline for the first week or so. Now that might have actually weakened the pipeline, and they might not have done that had they used a modern image which told them that, in fact, the pipeline was between the house and the street. So I started thinking, well, where does that pipeline actually go? And you can see, as we looked at before, here's the Pegasus pipeline as it goes under the neighborhood where the break occurs. And then you say, well, now where did that pipeline really go? Well, you can see it here, and you can see it here. And the rest of the time has been sort of obliterated by development and building and so forth. So if you live in, say, this neighborhood, that pipeline does something like that. But I'm sure you don't have to worry about it because naturally Exxon has told us that this is probably the worst break that could happen in this particular situation. So I'll do some little calculations. This is sort of the back of the envelope calculations. We know we have an outside diameter of the pipe of 20 inches. We know the thickness of the pipe. And believe it or not, there are calculators that tell you what the barrels per foot are. So we know that between one valve shutoff and the other, Exxon kindly put 18 miles of distance between the two shutoff valves. And that comes out to 95,000 feet. So then, if you look at the total barrels in that 18-mile segment, you end up with roughly 35,000 barrels. Now, does anybody remember how many barrels Exxon claimed that they spilled in this spill? Everywhere from 5,000 to 2,000. Originally it was 1,000. So if all the oil in a segment of the pipeline between the two shutoff valves were to spill in some future spill, 35,000 barrels times 42 gallons per barrel means you could be looking at a spill of 1.4 million gallons, and poor Exxon would be in such a terrible condition because there are no shutoff valves between those 2 points. And that's in each 18-mile segment of their 750-mile long pipeline. Now, you've been hearing a lot of information about toxicity and chemicals and how dangerous it is and how safe it is. Basically, Exxon says, don't worry about it, you're going to be fine, and everybody else is telling you this is not healthy, you need to stay away from this oil. So who's right? Well, I'm not going to get involved in that argument. I'm going to tell you exactly what Exxon says before they broke the pipeline, before it ruptured. This, you may notice, is Wabasca heavy crude oil from January 2013, written by ExxonMobil. I'm not making this stuff up. This is their official material safety sheet for what they call this stuff, Wabasca heavy crude oil, or what we call tar sands. And of course, that's what Canada called it as well at its source. So let's look at the composition of Wabasca heavy crude from the Exxon sheet. Well, when it comes to benzene, which we know is a carcinogen, the concentration of benzene in this stuff ranges from 1% to 5%. Now, that may seem like a small percentage to you, but when you think about benzene in, say, 200 or 300,000 gallons, and then you talk about 1% of 300,000 gallons, that's a lot of benzene. So I know there's a lot of new chemical names here for you, but let me try and simplify them for you. First, you've got the polynuclear aromatic hydrocarbons, the famous PAHs that you've heard so much about. The reason you've heard so much about them is because they're toxic, they tend to be long-lasting, they get into the water and the air, and they're really difficult to get rid of because they tend to be absorbed in fats and oils, and they tend to stay in the body for a long time. So for PAHs, Exxon tells us that this particular substance has greater than 0.1%. Well, what does that mean? Is that 1%? Is that 10%? What is greater than 0.1? You may have noticed that Exxon has never told you exactly what is in their substance. They say, hey, you want to know what's in it? Look up the Wabasca heavy crude oil. But unfortunately, the range for this particular substance is so great that it's not very helpful. Let's try another one, like hydrogen sulfide. It's greater than 0.005%. Well, that's a pretty small amount, but they don't actually tell you how much hydrogen sulfide is in this material. Do they know? Well, if they have a jar of crude oil, then they probably know what's in it by now, and they've never bothered to tell us. So some of these others, these are the famous ones: benzene, ethylbenzene, toluene, and xylene. They make up something called BTEX. And you can run the wiki search for BTEX, and it'll tell you that this stuff is really toxic. It's proven to be a carcinogen, but for humans, it's a probable carcinogen, and in fairly small amounts. These other chemicals, like cyclohexane, inhexane, naphthalene, these are sort of the lighter side of the composition. And by lighter, I mean they have smaller molecules, lighter than air, and they tend to disperse over a few days, even sometimes a few hours. And then you have sulfur, which is greater than 1%. So when it comes to the BTEX, you've got 1 to 5% benzene. You've also got 1 to 5% toluene, 1 to 5% xylene, and for ethylbenzene, 0.1 to 1%. So you're looking at least 3 to 4% BTEX, and as much as 15 to 20% BTEX, which is not good. So the first thing you should be expecting from Exxon is an analysis of the stuff that you've been poisoned with. And they haven't given that to you. So let's read on some more. It says that the potential physical and chemical effects of Wabasca heavy crude. Now remember, this is the Exxon sheet. I'm not making this stuff up. It says extremely flammable. Material can release vapors that readily form flammable mixtures. Vapor accumulation could flash and or explode if ignited. And material can accumulate static charge, which may cause an ignition. Well, clearly that's something you want to push into the storm drains and out into the wetlands, right? So let's talk about some potential health effects, because that's what we're here for. Everybody's concerned about their health, with good reason. If any of you have been sick in the last 2 months and it looked like flu or it looked like bronchitis, chances are it has something to do with what you've been breathing. So, potential health effects may cause cancer. But remember, Exxon has assured everybody that you're all going to be fine, that it's not going to be a problem. The danger of adverse health effects by prolonged exposure, let's go down a little bit. You've all seen skin dryness and cracking. If swallowed or aspirated, may cause lung damage. Let's see. Hydrogen sulfide, a highly toxic gas, is expected to be present. Not might be present, but is expected to be present. Signs and symptoms of overexposure to hydrogen sulfide include respiratory and eye irritation. Anybody had that problem lately? Dizziness, nausea, coughing, sensation of dryness, pain in the nose, loss of consciousness. That's just a little bit of H2S. Here's one. Odor does not provide a reliable indicator of the presence of the hazardous material. May be irritating. Aliphatic hydrocarbon gases, to some extent those are the BTEXs and some of the others, may build up in confined spaces and may cause dizziness, lightheadedness, headache, nausea, and loss of coordination. Continued inhalation may result in narcosis, unconsciousness, and possibly lead to death. But we don't think anybody's died so far. May cause central nervous system depression, and then about the skin, and then we have this careful warning. Exposure to benzene, and we don't know how much benzene you've been exposed to, because benzene is a light gas and can be highly concentrated early on in the spill and then dissipate, probably even before they got the monitors there. It says exposure to benzene is associated with cancer, particularly acute myeloid leukemia and myelodysplastic syndrome, damage of the blood-producing system, and serious blood disorders. So you shouldn't have anything to worry about, because all the agencies are here to tell you that the level of exposure that you have had is not injurious to your health, right? Of course, they don't know the level of exposure you've had, because when the pipeline broke and you woke up or were first exposed to it, there were no detectors, right? Environmental hazards, toxic to aquatic organisms, may cause long-term adverse effects in the aquatic environment. Therefore, let's push all this oil into an aquatic environment and see what happens. See what else we can learn from Exxon. Inhalation. Immediately removed from further exposure. Get immediate medical assistance. For those providing assistance, avoid exposure to yourself and others. Use adequate respiratory protection. Give supplementary oxygen if available, and assist ventilation in mechanical devices, etc. So here's an interesting one. How did Exxon decide what the radius was from the break to the evacuation point? We haven't seen any models. We haven't seen that they took into account the air or weather conditions. It seems like they came up with, and some people have said, that about 300 feet from the break is the danger point. And I thought about that for a while. Without any models, how do you come up with 300 feet from the break? Well, it just happens to be about the length of a football field. So I figured that's the criteria that was used for your safety. Let's get them about a football field away from the rupture. And that's only in one direction, right? That's just down the neighborhood streets. So you can read all this other stuff. It's all online. These are the weather conditions on the morning of the 29th and for the entire week. And you can see, as you probably know from this area, that the weather is somewhat variable. This is from the south on the morning of the 29th. By the 30th, it's more from the north, and the speed of the wind varies from 15 miles per hour to 5 miles per hour. So wouldn't it have made more sense if they had evacuated, say, since they haven't shown us any models, say 1,000 feet from the actual location of the oil at any given time? As the oil moves further, you'd want a radius of 1,000 feet from any place where the oil is. Well, that's not a difficult thing to do, but it certainly would move a lot more people out of harm's way. You've heard that Exxon has run integrity tests of the Pegasus pipeline, and of course, everything is fine. It's always fine. This is what you keep hearing about, the smart pig. It's a fairly sophisticated device that has all of these electronic sensors and can measure the thickness of the pipe. It can measure the electrical resistivity. It can possibly detect weaknesses. It can do a lot of things. And all they have to do is put it in the pipe, pump the oil, and this pig actually moves along the pipe at a fairly good clip at the speed that the oil is moving. So we know that it's available, but we haven't released any results. This, just so you know what to look for, is a sample of a pipe integrity test, and it actually shows the thickness of the pipe and where it has been thinned due to corrosion, external or internal, and where there might be weaknesses along the pipe. Of course, Exxon hasn't chosen to release anything that would in any way look like data as far as the integrity of that 800-mile pipeline. So, before I get into this, so my problem with Exxon is that they didn't use much common sense, as I think epitomized by the fact that they put their trucks on top of the pipeline, weakening it again. And they also broke every law that I can think of when it comes to pollution and toxicity, because, as I said, you are not allowed to change your oil in the streets, yet they were immediately focused on getting the oil away from view and away from the camera. And that's the only way I can interpret their actions, because if it were up to me, the first thing that would have happened is the agencies would have gone in, like the EPA, and said, you will close off these storm drains, and you will minimize contamination to the wetlands. And we will fine you anyway for the contamination that you have caused. So I didn't want to just stop here with some of the effects and some of the problems. I wanted to try and give you some solutions. And in order to do that, I need to talk about a device called a Qualified Settlement Fund. What it is it's a trust that the IRS says can be created to distribute funds for settlement. And it is a trust that is run entirely by the community. That is, the people decide who are the members of the trust, and the people decide how the funds will be distributed. And it has one other added benefit to the community, and that is that you can actually go out and raise money and donations for your community to help people, and you can distribute that through the trust as well. Now, why would you want to form a trust? Well, as you know, Exxon has offered to compensate people in 22 of the houses, and they decide which houses have been affected and which people will get how much and under what circumstances they will pay. The problem with that is that it divides the community. They select who is in and who is out, and if you are out, one option you have is just to sue them individually. And if you sue them individually, they will take you to court, laugh at you with their army of lawyers, and drag it out for as long as they can. And believe me, 20 years is not long for Exxon. There are many cases they have dragged out for 20 years. So you don't have any power if you're going to sue Exxon individually. You could go the class action route, which is a good approach, but the problem with class action is it puts you in an adversarial position where you are constantly fighting their lawyers and they are constantly fighting yours for a smaller and smaller piece of the pie. With a qualified settlement fund, which is a provision in the IRS code called 468B, that provision allows the community to establish the parameters. In other words, you get to organize, you get to negotiate, and you get to decide how large the community is going to be to make that, that negotiation. And the way it works is all you need is one or two people, preferably at least two, and they file a claim against Exxon. Then they go to a lawyer, any of your lawyers will do, and you can establish a qualified settlement fund. Then those people will expand and expand the trust until the trust is confident that as many people in the community that have been impacted are included that choose to be part of the process. And then it's a simple matter of assigning your claims to the trust. Now, who decides what happens to the money that goes into the trust? Well, it turns out that you get to name the trustee. In the example I'm going to show you, the person they named for a trustee was not a banker, not a lawyer, but actually a high school principal who the community trusted. They had a lot of experience, they had a lot of knowledge of the community, and they were the ones who made the final decisions. After votes of the people who were in the trust, they made the final decisions on how distributions would be made. So now I'm going to talk to you about a sample, an actual example of a trust. This is an area in Danversport, Massachusetts. It's on the coast in eastern Massachusetts, north of Boston. And on Thanksgiving morning in 2006, there was a paint factory here. And this paint and ink factory stored a lot of chemicals and some gases. And apparently, during the holidays, somebody left the steam heater on, and it got rather warm inside of that building. Unfortunately, by morning, it got warm enough to ignite the chemicals. And this is the image of the same spot on the next day. It destroyed 200 houses and businesses. Fortunately, no one was killed, which was a miracle in itself. And it also, see this boat dock? It destroyed about 300 boats. I'm sorry, 300 cars and about 50 boats. So it did a lot of damage, and the community wasn't quite sure how to respond. But a lawyer named Schlichtmann from New England moved into the area and said, maybe the community would benefit by a qualified settlement fund. Let me tell you a little bit about Schlichtmann. He is the lawyer from that fought the battle in Woburn, Massachusetts, which was made famous by the movie called Civil Action. Civil Action was a case involving pollution of the groundwater. People's wells were contaminated with chemicals from a chemical plant and also from a tannery. And Schlichtmann was portrayed by John Travolta. The book was called Civil Action. And it turns out that Schlichtmann is still in New England, and he's going to be available to us. In fact, that was him ringing a minute ago. I'm going to try and Skype in, but we'll need to take a break. At any rate, Schlichtmann is still a lawyer, and he is just interested in working with communities and underdogs to basically say, how can I help? How can I help you to organize? How can I help you to negotiate? Because communities all over this country need help when they are exposed to catastrophes and big corporations who leave big footprints and damage a lot of people.
Well, basically, the discussion we're having today is based on what I have learned over the last few decades representing communities that have woken up to an environmental nightmare. So it's really just kind of informed from that experience and not being happy about the legal tools available to me or the mechanisms accepted by lawyers for how to represent people, communities that have had a devastating environmental catastrophe. So it's really come from the Woburn experience and additional environmental experiences after that. So that's really what this is about, is how, what I was not happy with is that I learned that fundamentally, in this kind of situation in particular, the lawyer has to be a partner with the community. It cannot be in the kind of the traditional lawyer-client relationship where client brings problem to lawyer, lawyer takes over a problem, and then client gets a phone call in a year or two or three, to say how it turned out. That model does not work for something like this or problems like this. So all of this stuff that we're talking about really comes out of that frustration with that and trying to find a better way of representing people and making it more empowering, I guess, is the right way to express it. A way of empowering the community to be able to maximize the chances that they can get a result that will make a difference, as opposed to something that is very unsatisfying.
So what is the easiest way to form a QSF for a community like this?
Well, I think the first order of business, and the trust concept is really just trying to give legal reality to a fundamental decision that needs to be made. When these things happen, a lot of people who weren't really connected to each other. They've been part of a community, but it wasn't a community in a sense of people working together for a common end. They were off on their busy lives, as we all are. Then something happens, and everybody gets to...
We've lost you for a minute, Jim. We're buffering.
There's a whole bunch of other people in their neighborhoods, in their neighborhood that has been affected as well. And so the first order of business is whether the community gets it, whether they understand that this affected them all and that they all have to work together as opposed to go figure out separately how to deal with it. The trust is really just, did I lose the sound?
No, we're still on.
Okay. The trust would be the legal recognition of that fundamental decision. Now, the trust is not necessary, of course, for a community to decide to come together and form a citizens group or a group of people who are, coming together in a common strategy. But the trust gives a legal entity that gives a legal life to that decision. And it has all sorts of different kinds of benefits that just deciding to do it on your own without doing it through a legal entity provides. We'll talk about that. But so the trust is really just the legal entity that allows people to come together legally and put all their claims together legally.
And would you suggest that the Citizens Action Group take a vote and decide that they want to form a trust and then select a couple of people to go to a lawyer and actually file for the QSF?
Yeah, you notice I kind of stay away from the word QSF, the phrase QSF, but I want to talk about that a little bit. I do like the word trust because a qualified settlement fund, which of course the trust is a qualified settlement fund, has lots of different ways that it can be used, and they're all, have their value. Right now, when a lawyer represents a client and gets a recovery, they have their trust account, usually called an IOTA account, and that's where the money goes, and the lawyer has control over it. From a IRS standpoint, when the lawyer receives money into that account, that is considered constructive receipt from an IRS standpoint for the client, and so therefore the trust lawyer's normal trust account doesn't work. The QSF is another mechanism, a qualified settlement fund is another mechanism to collect that money. And the reason why I shy away from using QSF is because there's many different ways that it can be used, including basically a glorified trust account that the lawyer controls that could still qualify as a qualified settlement fund to receive money and still get some IRS benefits of non-constructive receipt. I use the trust to describe the kind of QSF I'm talking about because the trust requires a trustee. It requires a special relationship between the lawyer and the trust and the client to become beneficiaries of the trust. So you'll see that when I shy away from just calling it a QSF, and I talk about it as a 468B trust or as a settlement trust, or not even settlement trust, a 468B trust, because I like to set these up at the front end when there's not even a settlement, in the hopes that hopefully someday there will be a resolution. So to answer your question about how it gets done, first folks decide that they want to do it. And the more people who are affected decide to do it, the closer we get to the amount of people who are affected deciding together to work together, the stronger they are. Now, one person can decide to set it up, and two people can make it happen. But for the thing to really work, as a practical matter, it basically has to be a representative group of people affected, and the more people are affected who join it, the stronger the trust is, and the more, I think, increase the chances that you could have a better result.
And when is the trustee named?
Well, here's how it would work. It actually could happen right away. You first make the decision to come together and form a trust. You have to figure out who the trustee could be, and there are different ways of setting this trust up. You could just have an institutional trustee in the event that there's going to be, ever any money, and you always want to have an institutional trustee in the event that there is money, so that there's all sorts of proper accounting done, from a tax standpoint, from accounting standpoint, from a financial responsibility standpoint. But oftentimes what we do in these trusts is we set up a person who's the trustee who has overall responsibility, and that might be a member of the community that everybody respects and can help people come together in common decision making. And so it should be a non-beneficiary, of course, who should be the trustee. And then there should be an institutional trustee, that's what I prefer, an institutional trustee to be available as well to handle the money so that the individual trustee can deal with the personal relationships and the overall strategy, but the handling of money is handled by an institution. So, but it doesn't, again, when I say these things, these are options available. So to answer your question, today, right now, in 2 seconds, the group could say, I want to do it, and we want to have, we want Mr. Smith there, or Miss Jones to be our trustee. We respect her, and if they agree, then they can become the trustee. It's really a question of putting it together, going into a proper court, and there are many different courts that you could go to, and then getting it approved by the court. But the decision to form the trust, to act like you are a trust, to have a trust document drawn up, that all can take 24 hours. Getting it approved could take a couple of days or a week. But the approval is not actually essential to the trust of people coming together as a trust and starting acting like a trust.
Is the institutional trustee normally a bank?
An institutional trustee could be a bank. Now, there are very few banks and trust companies that are familiar with this kind of trust. And the institution that I use is called ATG, Attorneys Trust Group. They're up in Chicago. They're very used to this, and they've done these, and they don't really charge anything. If you go to a bank or a trust company to be the institutional trustee, they're very unfamiliar with it. They may not want to do it, or they'll want to, charge normal trust charges, and that wouldn't apply in a situation like this. So if you're going to do an institutional trustee, there are not too many places. There are probably about 2 of them. One is ATG that I've worked with. There's another one that Mark Wallstrom is a man that I work with in Arizona who helped me develop this concept. He has another group that's willing to be the institutional trustee. So I'm aware of at least 2 well-qualified institutions that would agree to manage this thing on a basis in which it really doesn't cost anything up front, unless and until there's money, which is also, of course, important. You don't incur charges that are not necessary. So to answer your question, there are precious few who could be the institutional trustee. Any bank could be it if they wish to do it. Maybe there's a local bank that would be willing to do something new, and that certainly could be something that could be done as well. But the ones that have experience with it are really probably only 2.
That sounds great. Let me see if there are any questions from the audience. People, yes, go ahead.
I want to find out how long you have to keep this qualified settlement for how long?
The question is, how long does the trust have to be in existence?
It can be in existence a long time. It doesn't have to be, if you're asking how long it could be in existence, it can be in existence as long as needed. I have one that I started in a case very similar to Woburn, and we started it in 2007. And we're now, what is this now? 5 years, going into our 6th year. And the trust, and actually there was a settlement in that particular case after only about a year or so. But the trust concept worked so well that everybody stayed in the trust, and the trust has been there managing funds and taking care of the families and growing with them. And so it's a very flexible, entity, and it really can fit the particular purpose. So it can last as long as it's needed and it serves a purpose. As far as something like this, it would be in existence from now until hopefully there's a resolution and a distribution, or a decision could be made, as was made in this other case that I'm talking about, for it to stay together and be something that will be there, a trust that would then be there for people and take care of them as an economic security blanket. And again, it all depends on the circumstances and how things turn out, but there's all sorts of different options available.
Okay. Does that answer your question?
Yeah.
One more question. Yes, go ahead.
Well, my question was actually about the extent of establishing this to begin with, because even though you said it's not necessarily the traditional client-attorney drawing up the legal papers, and how much does that usually cost, and how many attorneys would be familiar with that? Or is that something that could be done by a member of the group?
I don't know if you heard that question, but the basic question is, how much does it cost to set up one of these trusts and file it in court?
Okay, that's an excellent question. And I think the answer to that is that there are people who do draw up these trusts. They're available out there. You can find them on the internet, and they would charge to do that. People actually just charge for drawing up the trust document. You're right, you'd also need a lawyer to be able to file the trust document and get it approved. And there are lawyers out there who are familiar with this and could be hired to do that. So that's one option, certainly. Another option is that the lawyers that you have to represent you, if they usually do it on a contingency fee basis, that they would absorb the cost of doing that because they would see the trust as a mechanism that would be good for them, that would further empower their ability to be able to get a better result in a shorter period of time, or at least a way of bringing people together. So another model, the one that I use, and I'm very familiar with, is contingency fee lawyers who agree to do this, and this is part of the way they're representing the people, and it's part of the contingency fee relationship. So there's no cost to people because they're hiring the lawyers on a contingency fee, and the lawyers are doing it in hopes that eventually there'll be a recovery and they're going to be well paid for their efforts. So in a situation like this, clearly there are lawyers who would do this on a contingency fee basis. Ideally, having lawyers who like the trust or familiar with it or use the trust or would like to, that would just be part of the contingency fee relationship, and there would be no costs associated for the community, just like there isn't any cost to the representation. It's all result-oriented.
Okay, anybody else need a question? Yes, go ahead.
What's the downside? What are the reasons not to do this?
The question is, what are the downsides to creating a trust, and why would you not want to do it?
What are the downsides of doing it?
Yes.
What are the downsides? Well, I guess it's like asking, what are the downsides of people coming together and forming a group to try and deal with this problem? Is there a downside associated with that? Well, sure. I guess there's a downside in the sense that you're now working together with others. You are deciding to not act like an individual. You're deciding to act together as a group. It requires meetings. It requires consensus building. It requires those kind of interpersonal things that people need to do when they want to work together. So I would say that the downside of doing it is that you're making a statement about how you all want to work together, and it does require people to work together in a real way, which means have meetings, have discussions, have group decision making. So if you want to consider that to be a downside, I guess that would be considered downside. There's no downside in the sense that people have lost their freedom or lost their individual liberty or anything. They haven't lost anything legally, so there's no kind of downside legally to them. They've actually just added another legal component, another thing of value, another tool in the toolbox to deal with the problem. So I don't think it would be fair to characterize it as a downside, except in the sense that you now have to do things together and follow certain procedures together, which you would want to do if you're working together.
Okay, so we're going to take two more questions.
At what point do you get IRS involved?
IRS.
Yes.
At what point do we get the IRS involved?
Hopefully never. We're all reading the newspapers and probably a good reason not to. The IRS does not, this does not involve the IRS. What this is an IRS recognized vehicle. It came out of the breast implant cases, and it actually started to benefit corporations who were putting their money in the breast implant cases, but the plaintiffs couldn't get their act together. And the companies wanted to pay the money, get the tax deduction, and leave, but they couldn't get it done. And this kind of grew out of that frustration. So as these things often happen, corporate America was well served, the government responded to their need, and they created this concept of the 468B trust, which is very simple. Basically, the IRS set up these regulations, but it starts with a very simple concept, that if there's a court-approved trust for a personal injury, property damage, if it's a court-approved trust, then money can be put into that trust, and the person putting the wrongdoer, or the person causing the problem, or has the claim that they want to get resolved, can put that money in without having to worry about allocation or distribution, or who's suing who, or who's fighting over what. They can write the check, get their deduction, and go. Several folks saw that, including myself, as well. Gee, that also works the other way. If the IRS is willing to recognize such a thing, then the people who are getting the benefits, the potential beneficiaries here, can do the same thing, form the trust, have the money put in there, even if they haven't worked out all the allocation, or if there's divorces, or whatever. They can act together as a group, get a result, get a settlement with those responsible, and then decide later in a safe harbor, in an IRS recognized safe harbor, how to structure those funds to maximize financial planning and to lower the tax implications. That's one of the basic benefits of the 468B trust, when and if there's ever a settlement, is that it's not constructive receipt, and also gives people an opportunity to structure payments, to make use of the money in a way that is a safe harbor for the IRS. Now, a lot of these payments may very well be tax-free, and so there's not that kind of a benefit, but some might be, depending if there are businesses. If it's just property owners, perhaps not. But regardless, having a 468B trust does allow for financial planning and for the bringing in of financial planners to maximize and to be able to do things with that money that you may not be able to do ordinarily on your own. So it just opens up the opportunity.
Okay, I'm going to take one more question and then we'll wrap it up. Yes, go ahead.
I really have a question about the answer to my question. So was the answer to my question that the attorneys that you would appoint or use as your institutional trustees would set this up on a contingency basis?
She's wanting clarification about whether the attorneys that would be working for the institutional trustee, would they be on a contingency basis as well?
Yeah, I want to make sure you're very clear here. The lawyers, there's still the attorney-client relationship between the attorneys and the folks who are the beneficiaries, but it works just slightly different than the normal one. Right now, without a trust, without a legal entity for people to join, a lawyer has to have an individual representation agreement with each individual. Now, they may seek to form a class out of those individuals, which is a way of aggregating others who they don't represent, or they may just decide, like in a mass tort, to sign up individuals, and a whole bunch of them, and have individual contracts. Now, in my mind, the problem I have with that is there's a built-in conflict there, because when you represent two or more people and you have to zealously be an advocate on an individual basis, there is a built-in conflict. Now, we deal with it all the time. We don't really quite recognize it. When you have a trust, the individuals become better members of the trust, and now the lawyer is representing the trust. He's still representing the individuals, but as individuals are part of a trust, the conflict has now been removed. Because any issues of allocation, where one client, trying to decide what they should get vis-a-vis another client, it's done in the context of a trust. So the lawyer can do their job in representing everybody, getting the job done, but not being shadowed by or hobbled by the potential conflicts between clients. Because any issues of allocation is all done through transparency, and it's all done ultimately with court supervision that removes that conflict. So just to be clear here, the relationship is with the lawyer and the clients as a group in the trust, and they would have a contingency fee agreement with the trustee of the trust on behalf of everybody. That's how it would work. It's not with the institutional trustee. The institutional trustee is just a servant, like the trustee is a servant, and the lawyer is a servant, just like they are a servant.